Okay, well, welcome everybody. I hope everyone is well and staying healthy. And thanks for signing up for this webinar. We have a large crowd, and I suspect some of this is because we're dealing with a topic that is an increasingly important retirement planning issue, and that, of course, is dealing with diminished capacity. We have two fantastic guests to help us cover this topic. So let me go ahead and just make a quick introduction here. You can read about them in more specificity here shortly. But Lesley Mehalick is a trust and estate partner of McAndrews, Mehalick, Conley, Holtz, and Ryan PC, which is in Berwyn, Pennsylvania. At the American College, we're very aware of her expertise on this topic because she is also the adjunct professor of taxation and special needs planning at the college. And our other guest is Dr. Chris Heye, in Belmont, Massachusetts. First referred to us by Wade Pfau at the American College, Chris is CEO and founder of both WealthCare Solutions and WealthCare Planning. And you know what, I'll let him describe his practice to you as we go along. He combines passion and expertise in today's topics. That's a great thing to have. Okay, so I want to share a brief story in order to get things going. 2 days ago, and that was Sunday morning, I was walking my dog when a car slowly came up to me in the street. In the passenger seat was a very old and very concerned looking man. After mumbling about directions, he finally looked at me and had these plaintive eyes, and he said, "I'm lost." Well, I tried to ascertain his intended destination. Where do you want to go? And then a phone rang in his pocket, and he pulls out this ancient flip phone. Well, it was his daughter. And after a confused conversation with her about where he thought he was, I offered to take the phone and talk directly to his daughter. So we were able to work out a place for her to meet her dad just a few blocks up the street. Well, I tell you this because that morning I saw two things in that gentleman's face: fear and relief that somebody was going to help him. So the topic of diminished capacity is a difficult and topic to deal with both emotionally and intellectually. And today we really hope to come out with some new thinking on what we might call the 5 Ds that we can identify with diminished capacity. So first, how do we even define this ambiguous term? And then what are some ways to detect it? I mean, we're not psychologists. How do we know if someone really is struggling? And third, from a practical standpoint, do financial advisors really have a duty to disclose or otherwise deal with these competency issues? And how can we work with other professionals on this who may have mandatory disclosure requirements? And very importantly, how do we get out ahead of this risk in financial planning? I mean, what's the latest in documents that can help individuals and families with a roadmap for managing both the legal and the financial challenges that occur when the client's capacity is diminished? But also, how can we help clients assess the risk? The pandemic certainly has taught us the importance of pre-planning for competency and capacity challenges, right? So finally, the other topic we want to deal with is how to discuss this very uncomfortable topic with a client before it even becomes an issue. So there's a lot to talk about. So let's get started by just talking about a definition. Okay, Lesley, let's first level set this if we can with the legal definition. As attorneys, we both know that legal capacity to sign a will and testament is considered less than, for example, the capacity to sign certain legal contracts and financial arrangements. So how is diminished capacity generally defined? I mean, from a legal standpoint, what does that term really mean?
Yeah, Steve, it's really a great point. And I want to start with the general legal premise that the law does presume that every adult, so this is every person over age 18, the law presumes that every adult does have capacity unless and until a court makes a formal and legal determination that that person is incapacitated to the extent that they can no longer make responsible decisions for their own health, welfare, safety, and finances. So that's really where we start. The law itself presumes capacity, and that is regardless of the person's actual functioning. Now, that being said, when there has not yet been a formal determination of incapacity, that's where the attorney or the financial planner must come in and decide if the client has sufficient capacity for the task at hand. So the actual legal definition of capacity does vary. It's going to vary depending on the transaction that we're undertaking, as well as the nature of the decision that has to be made. Now, various states may have specific statutes that define capacity for different circumstances, and there also may be cases that set out these standards. So I do have to give the caveat that you do have to look at your own state's laws. But in general, there are some kind of general standards for capacity that we see. And the first one is that testamentary capacity. That is the capacity that a person needs in order to actually make a will for himself. And as you said, that is a really pretty low threshold. It does not require the person to be able to manage all of his day-to-day affairs. He could display some forgetfulness or erratic behavior. He could be diagnosed with an illness. None of those factors would determine testamentary capacity. Instead, in order for a person to have sufficient capacity to write a will, he really just must be aware of three different things. First of all, he has to have a good general sense of the nature and extent of his property. So does he own a house? Does he have stock accounts? Does he have retirement accounts? He does not need to know an exact balance on these accounts, but he is going to have to be able to have a general sense of his property that he has. Secondly, he has to know who his heirs at law are. These are the people who would inherit if he died without a will. So at the very least, he's going to need to know his spouse and all of his children. I remember a difficult case that I had where a longtime client was brought in by his two adult children who were his primary caretakers. He wanted to do a new will to name these two children because they were, working every day to take care of him. He was living with them. They were really his main caretakers. However, from our prior interactions, I did know that he had children from a prior relationship. In the meeting where we were trying to update his will, he was not able to name or identify those prior children for me. So unfortunately, that in conjunction with some other factors led me to the conclusion that he could not sign a will that day. He just did not meet this low threshold for testamentary capacity. So the person does need to know who his heirs at law are. And then the third factor is that he also needs to understand he is making a will, and by doing that, he is leaving his property to either his heirs or another person. Now, I would note that this testamentary capacity can be fluid. It can change day to day, or it can change from time of day. So it really is something we have to determine at the time the person is actually signing the will. As you note, Steve, this is very different from the standard for capacity for signing a contract. That is generally a much higher standard. In order to do any sort of contractual work, the person must understand the business being transacted. So that means if we are talking about a complex standard, then that standard for capacity could actually be quite high.
All right. Okay, I think that's a great job of legal level set. So Chris, now let's look at it from a client perspective. I mean, you've been involved in this issue for many years. And first, can you help us, I guess I'll call it size the issue. I noticed in your white paper, you indicate the estimated number of financial advisor clients at risk for diminished capacity is greater than 25%. So how big of an issue is, and then can you give us your thoughts on what is diminished capacity from the clinical or personal standpoint?
Sure. Thanks, Steve, and thanks to everyone who's joined us today. Yeah, Steve, it's a really big issue. A recent Wall Street Journal article recently declared that the greatest threat to the financial security of baby boomers is diminished capacity. Not a bear market, not a recession, not inflation. So what we do at WealthCare, what we do is we actually believe that the greatest threat to the financial security of most adults is not poor investment portfolio performance. It's really the biggest threat to financial security and wellness are these health and longevity related factors. And, for better or worse, near the top of that list is the threat posed by diminished financial decision-making capacity. So I have experience of dementia in my own family. My mother, her mother, and sister all died of dementia. I also have friends whose parents lost literally millions of dollars as a result of some combination. It's millions, not thousands, not tens of thousands, it was millions. Some combination of diminished capacity and poor decision-making and financial exploitations. And, these were not, I know the children, the children who are very bright individuals. One went to Stanford, another one's a very successful entrepreneur. These are very smart people. And yet and one of them, the son was a doctor, and yet their parents just made some horrible financial decisions. So at some point a little while ago, I decided that not enough was being done to protect older adults. And I ended up, another issue is a good friend of mine is the head of geriatric psychiatry at Mass General Hospital, Dr. Tony Weiner. I'll talk more about him later. So we did a study to try to better understand these relationships between aging, diminished capacity, and financial decision-making. So part of what was compelling us to do the study is the scope of the problem. So Steve, you asked how big this is. And so one thing now is most of us know the population's aging. So between now and 2035, which sounds a long ways away, but it's only 14 years away, the number of people over the age of 65 is supposed to grow 6 times faster than those under 55. And by the time we get to that date, it's expected that there'll be more people over the age of 65 in the US than there are under 18 for the first time ever. So our population's aging. I'll tell you how I get to that 25% number. The ARP estimates that about 10% of adults over the age of 65 have Alzheimer's. But as many of you know, that's not the only type of dementia. There's probably another 2 or 3% that have vascular dementia, or my mother had frontal lobe dementia, Lewy body dementia. So that's another few percent. And then in addition to that, another estimated 15 to 20% of adults over 65 have what is called mild cognitive impairment. So that's what, when you add those two numbers, when you add 13% plus 15/20%, you easily get up around 25 or 30%. So when you combine that with the fact that the average age of a financial advisor client is estimated to be 64, right, it tracks very closely to the baby boomers. So that means, most of their clients are older, and probably 25%. And what I like to think about is, how would a financial advisor react to other threats, things that threaten their 25% of their assets under management?
Yeah, that's a wake-up call, if nothing else. Well, why don't we go ahead and talk about then, how do you detect it? I mean, what are the markers and indicators? And I guess I'll throw that at you, Chris. What are the warning signs of diminished capacity?
Yeah, so I like to think of these sort of into 3 groups, and a lot of this came out of the clinical study that we did at Mass General Hospital. So the 3 groups, I like to classify them as what we call cognitive issues. Now, those are sort of the typical things when you think about, memory loss, or the person, unfortunately, the gentleman that you spoke with the other day, who's disoriented, he was confused, it's called spatial and temporal disorientation. So there's those types of issues that obviously are going to have a major effect on financial decision making. But I think people tend to sometimes focus on those issues to the exclusion of other issues that are really important. And these fall under the category of what I call behavioral issues. One of the cases of financial exploitation that I was talking about was clearly a behavioral issue. It was a gentleman around 70 years old. He probably would have aced the cognitive test, but he was recently divorced. He was spending time with younger women. He was, had new business partners who wanted to work with him. So these behavioral factors that include things like impulsivity, loneliness. The former Surgeon General declared loneliness to be the #1 disease in America. Wow. So loneliness, overconfidence, depression, anxiety, there have been clinical studies that show all these can have deleterious impacts on financial decision-making. So that's another factor to look out for. And finally, the third set is just poor financial literacy. I think a lot of us know people who are very bright, but they just don't have good financial literacy. And as a result, they may end up making poor financial decisions. Okay. So from an advisor perspective, these are the things that we suggest you look out for. We have an assessment that we built that was based on the clinical study that's designed for financial advisors. It's about a little 10-minute assessment that includes checks on these three factors that advisors, we have many advisors now who are using this assessment with their clients. It only takes, again, about 10 minutes, and we haven't heard about much pushback from the clients. We'll talk more about this later, but clients know this is an issue, right? I mean, especially if they're 64, if they don't have it, their parents have had it, they've gone through it. So we'll talk more about that later, but I think that those are some of the things that you should watch out for when you're dealing with your clients.
That's good, and that's let's move on to kind of from an empirical standpoint. Lesley, you have this law practice, so I'm sure you've seen this a lot. I'm curious if you have any experiences on that, or also is there anything you're doing kind of at the preventative level, like some people record will ceremonies when it's a little questionable.
Yeah, unfortunately, it's something we see every day. And as you know, most lawyers are not medical doctors or psychologists, but from a practical standpoint, we have to make capacity decisions all the time. And we always have to make sure that our client is able to understand the legal action, that they understand their options and the consequences of their decision. So in general, I will say that, again, lawyers ethically are going to presume that the client has capacity. But also, I think it's really important to make sure that we're making every effort we can to enhance the client's capacity. So if I'm meeting with an elderly client and I am observing some signs of a potential diminished capacity, that could include something like short-term memory loss. Maybe they ask me a repeated question over 20 minutes. Maybe I see them kind of deferring excessively to others. Perhaps there's some difficulty with simple math, whatever it might be. If I'm observing some sort of sign like that, I am going to make sure that I take extra steps to do my best to determine the client's actual ability to understand what we're doing and to understand their capacity. So the first thing I try to do is this sounds simple, but the first thing I really try to do is to respond to the client's physical and emotional needs. So I'm going to meet them where and when they're most lucid. A lot of clients with early dementia might be most lucid in the morning. They might be much more comfortable at their own home where they're in their own setting. They might feel very disoriented in my office where they've only been once or twice, but at home they might be more comfortable. So in those cases, I will make home visits. I'll try to visit them in the morning if that's at the time of day that they're best. I've found sometimes a series of shorter, more focused meetings is needed. I've certainly had cases where the client is very lucid the first 20 minutes of the meeting, but towards the end of the hour, they're starting to get more scattered, and I'm concerned. So sometimes we'll do that. Other things are just things like limiting distractions, using a bigger font on a will just to make it easier for them to read, doing my best to speak slowly and clearly, which I know I need some practice on, and of course, just exercising patience. And then in regard to avoiding any sort of will contest, whenever we're doing a signing, I always make sure we have 2 witnesses and a notary present. So it's not just my, word at the end of the day. In some cases where I am particularly concerned, I might seek guidance from an additional professional. So of course I need client consent to do this, but if the client consents, we can have a doctor evaluate the client and then provide me with a letter as to the doctor's medical opinion of the client's capacity. In other cases, Steve, like you suggested, maybe we do record the will signing. It's easier than ever today with the iPhones. You no longer have to drag out the video recorder. You can just pop up your phone. But when I do that, I'm going to make sure I ask those 3 standards for testamentary capacity so that we have a real clear depiction of that. I do that case by case only when I think that it's, really going to be a solid recording there. Potentially, we can do screenings like what Dr. Heye is talking about, or a mini mental status exam. But again, the lawyer is not, a medical doctor, so it's just going to be kind of a global or crude assessment and not necessarily talk as to that testamentary capacity, which, like I said, is a pretty low threshold.
Mm-hmm. Well, let's discuss this kind of as a practical question about what do you do if and when it happens. So, I mean, let's use a scenario that comes up way too often. Is you have a client and she's elderly and you notice that she's been taking a lot of withdrawals from her brokerage account. And when you ask her about it, she's sometimes confused about it and sometimes defensive about it. And, your spidey sense as an advisor tells you that maybe your adult son who lives in town has something to do with those withdrawals. So it goes to one of the questions we've already had in the Q&A function is, how this fits into elder abuse. So you're worried that diminished capacity is leading to elder abuse. So traditionally in the financial services business, there's not much we could do about it, at least officially, because there was no shield from liability. Now, this has changed recently, as I think many people know, with the Senior Safe Act. A little over 3 years ago, the Senior Safe Act was passed by Congress to protect what was called covered financial institutions, but that includes financial advisors, broker-dealers, and agents under that. There's some specific rules, such as the report has to be about potential exploitation of a senior citizen who would be someone 65 or older, and has to be sent to a covered agency, and that could be SEC, FINRA, even an adult protection service. We won't go into the details today, but let's think about this opportunity to disclose. I call it an opportunity because we can work in consort with other professional advisors. What Chris, I noticed you called them LRC professionals. I like that. That's legal risk and compliance professionals. So Lesley, as an attorney, a lot of our audience here is financial advisors. So currently their overall disclosure duty is more voluntary than mandatory, though some states do have a mandatory. It'd be helpful if you just give us a general idea of the attorney's duties relative to detecting and reporting diminished capacity, particularly as it applies to elder abuse.
Yeah. Well, Steve, every state has laws about elder abuse and reporting that. In many states, attorneys are mandatory reporters. In other states, attorneys are voluntary reporters. But aside from that, attorneys are held to certain ethical standards. And under those, in many cases, we are obligated to report. So ethically, attorneys can and should voluntarily bring protective action whenever they reasonably believe that the client has diminished capacity, that the client is at risk of substantial physical or financial harm, and that the client cannot act in his own best interest. Now, what that protective action is can really vary. It may be as simple as reaching out to another family member to let them know that this is happening. It may be a case where we have to report it to the local Department of Aging, or potentially, if it's even more significant than that, maybe we have to report it to local law enforcement. So it really is going to vary case by case. In addition to that reporting, attorneys also are able to reveal certain limited confidential information when it's needed to protect the client's best interests. Normally attorneys are not able to reveal any sort of confidential information, but this is one of the few exceptions where we can. I personally, unfortunately, very recently had a very, very difficult case. I had longtime clients. They were a married couple. We had done estate planning for them over the years. They had named their son who was their oldest child, as their power of attorney, as their executor. They had put him in all of the important financial roles. And I actually knew him well as well because he had participated in certain meetings. Unfortunately, as the years passed, the father passed away. And then later on, the mother developed dementia, which got to the point where she was no longer able to manage her own affairs or was no longer able to make decisions in her own best interest. So down the road, what happened is that we were contacted by the family's daughter, and they said, you know, the son, who was the power of attorney, unfortunately developed very significant addiction issues. He got divorced, he lost his job, you know, he was living in a hotel, and he was misusing the mother's assets. It was extremely unfortunate. We tried very hard to have him resign as the agent under the power of attorney, but he refused. So unfortunately, in that case, the end result was that we had to take steps to protect the client, and that included getting an independent guardian appointed for her. So that was an independent guardian. It was a local lawyer who was able to manage the finances, resolve issues to the extent possible with the family, and also make sure that the mother's money was used to care for her, which was really what was needed. So, you know, we do everything we can to try to avoid eventualities like that, but unfortunately, it does happen in some cases.
And, you know, let me branch from that over to you, Chris, because when we were talking before the webinar, I mentioned a situation I'm running into, because Lesley just talked about a legal solution with guardianship. But the situation I'm aware of is this affluent couple in their 90s who are having some real problems. They have an institutional trustee, and they have a trusted agent under a power of attorney who I know. But all of us are feeling really frustrated because the couple's problems are escalating. They've moved 3 times in the past 2 years, twice during the pandemic. And now there's the risk of violence between the two. So first, when it comes to a tangible issue like violence to oneself or to others, how is this dealt with at the clinical level? Because, you know, law alone won't do it. And then maybe more germane to our audience, how can an advisor help with some of these things up front? I mean, what tools are there to think about diminished capacity in advance, like you started to talk about earlier?
Yeah, these obviously could be very difficult situations. And so the first piece of advice is that, you know, you try to prevent these from happening in the first place. And so that's what we you know, frequently and consistently suggest that, you know, an ounce of prevention is worth a pound of cure. So there are a lot of things that advisors should be doing starting as early as when clients are in their 50s, because we know that basically bad things can start to happen health-wise when you're in your 50s. So first step is to try to have these conversations early on. You know, really importantly, try to get to know other family members early on, because you're probably going to need them later. And sort of to Lesley's point, usually the more the better, because if you just have one person who's in charge, you do run the risk of that person being a bad actor. So if there are more than one kid in the family, try to get them involved. And if there is a bad actor, usually the siblings will know. The siblings will be able to help identify who that bad actor is. But again, first of all, so, you know, try to follow some, you know, just basic preparation steps. Again, they're in the white paper. I also authored a recent paper in the Journal of Financial Planning. It's got these same steps. So communication is really important. Communicate early and often. You can't communicate too much. Get to know the family members. And even in advance, say, okay, you're great now, but what should I do 5, 10, 15 years from now? If I suspect you're having trouble making financial decisions, what would you like me to do? And again, it's when people are when they're younger, they're not as defensive about this because it's longer in the future. So it's always easier to do it sooner. And so there's even things now like diminished capacity letters that some advisors use with their clients that have to ask that question: should I, you know, who should I talk to? You know, can I go to your kids? Can I go to your spouse, et cetera? So as Lesley mentioned, getting all those legal documents really important. I recently talked to a lawyer and a very experienced lawyer, and he said, you know, what he thinks is the most important estate document is the power of attorney. And I have to say, in my experience, you know, it's been that way as well. because if you really need to start putting constraints on certain people's decision-making behavior probably sooner than you might want to think. So that the first step is to try to avoid these situations. Once you get in these situations, they can be very difficult. You know, I work with a brilliant psychiatrist named Dr. Ned Hallowell, and what he likes to say is never worry alone. So when you need to get help, you know, get help. And as Lesley said, once you get to the point where people are being violent, that's outside, you know, any lawyers, pretty much any lawyers or any financial advisor's domain. You really need to, hopefully at that point, you're talking to the kids, you're talking to other family members, and these people need professional help. So they need to see at least their primary care physician. They probably need to see a geriatric psychiatrist or some sort of similar specialist. Try to get them help. So again, you don't need to be a doctor, but what you can try to do is help your clients get that special care that they need. You don't need to do it, but what you can do and try to do is help them find that care, because it's these situations can get ugly pretty quickly.
Okay, and I just want to make sure that well, now's as good a time as anyway. Why don't you tell us a little bit about your actual capacity assessment? I think that's a good preventative thing to be aware of.
So again, this was a study conducted at Mass General Hospital under the auspices of Dr. Tony Weiner, who's the head of geriatric psychiatry at Mass General. We also work with Andrew Lowe a little bit at MIT. We did this about 7 years ago, and the idea was that the motivation was, you know, personal experience, but also this idea is that, you know, the population's aging, and we're getting to the point where people have the most amount of money they've ever had in their life at precisely the time where they're becoming less and less capable of making good financial decisions. And so that's a real problem, both sort of at a personal level, even at a macro level, when you think about it. I mean, do you want people giving money to, you know, Nigerian lotteries and princes and Jamaican lotteries, or do you want people giving money to their kids' education or you know, a viable charity? So right about this time too, a study came out that suggested that the peak age of financial decision-making is 53. You know, not 63, not 73, 53. And we've seen this in some of our own data that we've collected using this assessment. So again, if you think that peak age of, if you think about the average financial advisor client is 64, most financial advisor clients' best decision-making days are already behind them, maybe well behind them. So anyway, we did this study and we were trying to understand basically what are the relationships between cognitive impairment or cognitive decline, financial decision-making, and aging. And we had a sense that it wasn't just memory loss. There's a lot of discussion, especially back then, people were talking about memory loss. I think maybe because it's a little easier to talk about memory loss than dementia. But we found it's really issues around executive function. So these are things that it's sort of a technical term. It means ability to plan, to organize, to connect the dots, to control impulses. Those seem to be the most important for financial decision-making. So what we tried to do is take those insights from the study and put them into a short little quiz. So we didn't want to make it too long. We didn't want to make it too intimidating or scary. So it takes about 10 minutes. And again, it covers those cognitive and behavioral and some financial literacy questions. And so that's, if you go to our website, you can find out more about that. You need to be a subscriber to use that with clients, but contact me and I can give you some more information about it. At some point, we may just let everybody use it. I mean, I think that's kind of always been my goal, is just to make this sort of a public service. But that's what it's for. And again, it's for financial decision-making. You know, Lesley mentioned the mini mental status test. There are mini mental and the Montreal cognitive assessments. Those are things that a doctor will use. But again, my concern is you can ace some of those tests and still be, have deficiencies, have these behavioral issues, or have these financial literacy issues that are going to make you less capable of making good financial decisions. So those are also part of our assessment.
Yeah, that assessment tool makes so much sense. It lays down the ground floor, so that's super. Let's go over to the legal side. I noticed we're getting some Q&A on this too. We know every state's different, And Lesley, I'll give you the tough task of trying to summarize all this in a few minutes, but we basically have a number of tools we can use, specifically power of attorney, financial, and medical. Interestingly, though, I just saw a statistic that less than 25% of people actually use those. But most states allow some kind of an advance directive and living will. And lately, I've noticed that a number of states have started to allow pre-directing of who the client would like to have to serve as a legal guardian if something does happen, like the case you gave. But Lesley, I mean, at the practice level, how do you work with these tools, and how can they help clients avoid or at least deal with these problems before they happen on the legal side?
Right, absolutely. And, Chris just made such a great point there. The first tool that I think attorneys and planners need to look at is talking to clients and asking questions. Particularly if it's a new client, they may not be willing to just divulge that there are some potential issues that they foresee, coming down the road when it comes to diminished capacity. These, as we've been saying, are such hard topics to talk about, and it can be embarrassing or just whatever they might think. So it really, really is our job to ask these questions so that we can plan for it. But from the legal side, I mean, first and foremost, it's just essential that every adult client have a financial and a medical power of attorney. Name an agent in place who can make decisions for you if you're unable to. With the power of attorney, the person making it, they're called the principal. They still retain full ability to make decisions themselves. They can revoke the power of attorney if it's no longer appropriate. They can change their agent. So it's not something that you should be scared of. It's a preventative document, and it is so very important. In my state, Pennsylvania, where I primarily practice, the power of attorney, in the document itself, the principal can name who they would want to serve as their guardian. We can do that for both financial and healthcare related decisions. So that's something I always like to do. If we think, or maybe we just do it preventatively, we can address certain nursing home issues. We can certainly maybe try to limit the use of arbitration agreements in nursing homes, because sometimes that can lead to a lot of problems down the road. But there's no reason why your principal can't address what type of nursing home they might want to go to. Similarly, there is usually, most states have something called a mental health power of attorney, where if there are any mental health issues, we can really specifically address the types of treatment they would or would not want, or hospitals they would or would not want to go to. So the power of attorney is so important. And, while there are a lot of forms on the internet for a power of attorney, the document itself is not just a form. It truly, truly can be modified to fit the client's best interests and needs. And it's just so important. So we definitely want that in place. We want agents named, and we want successor agents named. Hopefully that if the principal develops diminished capacity, having that power of attorney in place will prevent the need for guardianship or any further more restrictive measures. Secondly, we do want to make sure they have a living will or advanced healthcare directive. That's a document that speaks specifically toward end-of-life decisions. Another thing we can do if diminished capacity is a concern is we can transfer the client's assets into a revocable living trust. It's one that doesn't do anything for tax purposes, but we can have a trustee in place to manage the assets. If there's some family infighting, we might want to look at a corporate trustee. And one thing that we might want to do as well is include what we call a trust protector provision. That's a provision where we appoint just a third party, somebody independent, who can have a little oversight over the trustee and remove that trustee if needed. So in my case that I mentioned before, if all of the client's assets have been in a trust with a trust protector, we might have had an easy out to remove the bad actor child as the trustee. In addition to that, I do recommend the family meetings. I think conversations and being upfront about the parent's plan is very important. The attorney can be involved in that. The clients can also set out their wishes in letters that accompany the legal documents. It's hard to kind of put that personal side of it into the actual legal documents. If the person's really developing diminished capacity for their Social Security Social Security payments, Social Security allows for a representative payee who can have control over those monies. So that's something clients should just be aware of. And then one thing I just wanted to mention is a lot of clients ask about putting all of their assets into joint accounts with a child. While that certainly does allow the child to have decision-making abilities for that joint account, that can have a lot of unintended consequences that the client may not be aware of and may not always be the smartest decision. First of all, there could be gifting implications. Secondly, it could completely disrupt the testamentary plan that we've designed with the client. It could be completely at odds with what they have in their will. And generally, we're not going to recommend that. Instead, whoever is the power of attorney can be an actor on an account. So that's usually the preferred way to handle that. There may be a small joint account that they do for convenience purposes, but in general, we're not going to just be adding one child onto all of the client's accounts. Guardianship is always the last measure. Under the law, we are really supposed to try to do the least restrictive measure possible to protect the client and their best interests. So guardianship is that official, or conservatorship as it's called in many states, that's that official court proceeding where we have a doctor give medical testimony as to the client's incapacity, and then the court declares that person incapacitated and appoints a guardian or a conservator in their place to make all decisions moving forward. That process invites the court into your life, and it involves a lot more significant reporting requirements. There may be restrictions on how money can be used, and there's just a lot more court oversight. So while it is an important process, and it's good to know it's out there if needed, if there is a true case of abuse that can't be prevented in any other way, it's definitely the last case measure. We don't want to go there first.
And Lesley, I really want to thank you for not mentioning Britney Spears. That was wonderful. So moving on, we've got so many good questions. I want to at least get to some of those, but first I do want to get something from you, Chris. As kind of that last topic of, and we've kind of gotten into it a little bit, but how do you discuss this with the client? I mean, this is uncomfortable stuff. So I'd just like to get some of your thoughts on that before we then move into the Q&A.
Yeah, thanks. It's a great question. I understand a lot of advisors have difficulty addressing these issues and having these conversations, and that they don't have training in that area, and they may feel that that's not their role. But I guess the thing that I would like to impart is that it's really important, but it's also probably easier than you think. You don't need to be a doctor. You really don't. You don't need to be a psychiatrist. But I like to say you just need to be a human being that can show a little empathy. Think about how you would want someone to treat your parents or treat an elder family member. The other thing that, again, I've learned a lot from Dr. Weiner at Mass General Hospital. And he talks to older adults and their families, every day. He's been doing it for 25 years. And, even he confronts these situations, sometimes older, it's usually men, they get obstinate, they get defensive, they don't want to talk about it. So I've learned a lot from him, and there's a few tips. And we also have another white paper that I can point people to that's got these conversation tips. But one thing is to just talk about, the risks of not talking about this. Just try to say, look, I know this is hard. The only thing worse than talking about this is not talking about this, kind of that conversation. And the other thing is, ask open-ended questions. And again, we have a list of some of those. You can just ask, how are you feeling about your health? Do you have any concerns about your family health? Dr. Ned Hallowell says, try to get people to start telling their stories. Most people actually do want to talk about this. Mm-hmm. If you look at surveys, every survey that I've ever seen that asks people what their biggest financial fears are, it's never a market downturn. It's never inflation. It's always a health event happening to me or my family member, high healthcare costs, long-term care costs. These are the issues. What do you want most from your advisor besides basic financial advice? It's always around health. And sort of a silver lining from the the COVID pandemic is that this is on top of everybody's mind right now. So I think now's a better time to talk about this stuff than it was 2 years ago. Again, we've got some helpful tips on our website, some conversation starters, but don't feel like you need to be an expert. Ask open-ended questions. Talk about the risks of not discussing this. The other tip is, I thought it was a really great idea. There's a woman who's a sort of a life coach. When you phrase the question, you say, "I know this is a difficult subject." So start out that way, right? So that sort of puts the user's mind at ease. The listener says, "Oh, this person recognizes that I'm having trouble talking about this." Say, "I know this is difficult. I know this is a hard time. I know you may not want to talk about this, but," and I think that's a technique. I've actually used that technique in myself, and that's another good way to start this. And again, I think with most of your clients, you're gonna open up the floodgates. And I'll just finish by saying that when I talk to my friends, I'm over 50. When I talk to my friends, we're not, even when we're talking about financial stuff, we're not talking about ETFs, or what the Fed's doing. We're talking about how am I going to take care of my parents, or the conversations always come back to healthcare. So this is what people really, really do care about. And if you can help them, if you can help your clients in these areas around health, around longevity, family health, I mean, what better way do you have to, strengthen and deepen your relationships with them, especially if you can help them somehow with these family-related health issues? So, again, it's easier than you think. It's going to be very worthwhile doing so, and you're really going to help out your client.
That's great. I'm getting a lot from this. And by the way, we're going to move into question and answers. We're getting some of these questions. One thing is the link to this recording is going to be available because some of you said, I can't write down notes and this is great. You'll have that opportunity. I'm going to do the same thing. And also we're going to make it available to you like Chris's white paper, which is really a good read. It was written this year, so it's during the COVID crisis. So a lot of that's going to be available, and yes, we'll make these slides available. As we move into the Q&A, I'm monitoring what we have here, and one thing I'd like to address is, Lesley, a little more on POAs, but let me start powers of attorney, not powers of appointment. I just want to point out that's because at the American College we teach this, and it's something to understand. This is why we need to coordinate with the various professional communities, because as an example, I'm a snowbird, and so residence is in Florida, but I spend time in Iowa as well. Florida does not have a springing power of appointment, nor does Minnesota. Iowa does. Someone asked about springing power of appointment. So you need to know where you are. And in my case, and I was telling you, Lesley, before that I actually carry documents for both Iowa and Florida for powers of attorney, but not for a will, because you can only have a will in wherever your domicile is. So could you just talk a little more about how the powers of attorney can help? And I would throw in the caution, because everybody's saying it's great and it's wonderful, and it is, but it also could be a license to steal. And I've seen some cases on that too. So thoughts? We're getting a lot of questions on power of attorney.
Yeah, the power of attorney is an extremely important document, but as you note, Steve, it is also extremely subject to abuse. A lot of states are tightening up the powers of attorney now, and a lot of states now have certain powers that they call hot powers. What that means is that these are things that if they are not explicitly included in the power of attorney, the agent does not have the authority to do them. And I discuss these items with clients in meetings. So some of the hot powers that you typically see are the ability to gift money away, the ability to change account owners, to add the agent on as a co-owner, and the ability to change beneficiary designations. There's others, of course, but those are three really big ones. So if the client has any concerns we may want to exclude those hot powers. It's really difficult because including them provides a lot more flexibility. Just say, for example, that a child who is fully functioning ends up in a terrible car accident and is disabled. And we want to change the client's estate plan to name a special needs trust for that child. If we take all those hot powers out, we may not be able to do it. But, it's something that we just really make sure we discuss with clients because there is such a potential for abuse.
And one related question in a way, because I had 2 or 3 on this, is you were talking about the diminished capacity of somebody having the ability to be a testator for will. Several people said, well, if that day they're not up to it, but another day, like you mentioned in the morning, they are, is that okay?
Yes.
Okay.
Yeah, it's fluid. It's fluid. They could be okay in the morning and not in the afternoon.
Okay. Well, let me ask, and really both of you could answer this. Let's start with you, Chris. Several questions go into the very realistic situation of people who do not have children or otherwise close relatives. From your perspective, it's not unanswerable, but how do you deal with that fact in real life when the people are in a situation of diminished capacity and really have no close heirs to watch over them?
Yeah, it can be very difficult, and sometimes the advisor or the attorney will take on that role. You can also try to, there's the extreme versions of that as you start calling protective services and something like that, and sometimes you have to do that. But you'd rather not get that far. You can start by talking to sort of local organizations, local chapters of Alzheimer's organizations. There are a lot of local chapters of these organizations that are designed to help older adults. So I think in general, if you don't have a relationship with one of those organizations now, I would go ahead and do that. Find a good one. Find geriatric care managers are also another really good resource to get to know. So and then also to the extent that you can have a relationship with the clients, any sort of medical provider that they have, maybe they have a caretaker. But that's a difficult situation. Again, it suggests the need for that pre-preparation, but there are still some steps you can take. Going a little bit, you got to broaden your network a little bit, but go outside. There are these very support agencies that are popping up just about everywhere that can help you out.
And related to that, really for both of you, I suppose, Lesley, you might have some thoughts on this, is several of the advisors here are saying, well, what can I say to the attorney or to the doctor? And what can I? The humanitarian in me says disclose everything. The compliance person in me says, oh, be careful. The Senior Safe Act is not just a check the box thing. And so your broker dealer, your RIA are going to have their own rules about this. So several of you that asked the question, can I contact the attorney when I suspect elder abuse, that kind of thing. And also, as you point out, Lesley, states vary on this. So first and foremost, do check with your own regulatory authorities on that. But any thoughts, Lesley and or Chris, on how we can interact with other professionals to do the right thing for the client?
Well, personally, I like it. I love it when we can work together as a team. And in an ideal situation, we will have a long-standing relationship. And, perhaps the clients have given the financial planner's disclosure so that they can give certain information to me, and we maybe have had that in place for a long time. So in a lot of those cases, by conversations without necessarily divulging anything confidential, we may be able to work together to find a solution. I recently had a financial planner reach out to me for a longstanding client and suggested that maybe we consider a revocable living trust. And we met with the client, and through discussions, I determined that that also was a good idea. This is also someone who does not have an immediate family member in place, so she really does need some additional protections. So I kind of feel like if we can work together as a team and have established a relationship, that may facilitate some of those issues.
Yeah, and Steve, the only other thing I would suggest, or that I would mention, is that there are, what I'm looking at now, there are some, even the medical profession struggles with this. because what you want to do is you want to sort of balance the patient's autonomy and independence with, this concern for their safety. And so where do you draw the line? So I'm looking at now, there's some new guidelines out that a group of neurologists has just come out with. So I'm starting to look at those more closely, but these are the same issues that advisors are going to have to, and people like Lesley are going to have to deal with increasingly, is how to balance those two, how to, keep your client, make sure that they preserve that independence, but at some point in time, it's not safe for them to be making these types of decisions on their own. So that is a tricky issue. That's something I'm going to be doing more research on, and I'll be talking about more in the future, how to do that better.
Speaking of learning more, I've had a couple inquiries about what the American College does. And just as an example, I teach the estate planning one, and we talk about a lot of these POAs and that kind of thing. And we also have it in the RICP designation. And of course, Lesley, you're teaching special needs. So we have things we can do at the American College on this. And then a lot of it is beyond that. That's why I was excited to have Chris here, because he's bringing an aspect that's different for us. Again, we can deal with a lot of things legally, but at some point when the couple's going to be violent to each other or someone else, then you have a whole different issue to deal with. Okay, so we've gotten there. We've got 1 minute. Any last thoughts or comments that you want to share with us before I give the CE code and thank everybody? Well, first of all, I want to thank you too.
Thank you, Neil. Thanks for having me, and thanks for bringing light to this issue. It's a really important issue. I think the more we talk about it, and the more we have sessions like this, the better off we all are. It's not going away. It's only going to get worse. So let's confront it. Let's not ignore it. And again, we can do this.
Works for me. So thank you both. I really appreciate it. You're coming from such interesting perspectives. And to the audience, thank you very much. There's a ton of questions. A number of them I'll be able to respond to you. And so I'll take care of that. There may be some specialized ones, but we do get back. We'll get you the link to the website for Chris and the white paper. We'll get you the link to this session and the PowerPoint. And it's the top of the hour, and we always try to stay careful to this. So we very much want to thank you, Lesley. We want to thank you, Chris. We want to thank you, audience. And stay healthy. Take care.